Welcome to Study Room. This is a CCA CCS Rule 1965 third series. We have already done two series. You can watch all the series and upcoming series also. Thank you. Please subscribe the channel if you have not subscribed yet to get the latest videos from Study Room. Question number 1. What is the age criteria to consider the appointment of retired officer as inquiry officer? Option A, not more than 60 years as on 1st July of the year of empanelment. Option B, not more than 65 years as on 1st July of the year of empanelment. Option C, not more than 70 years as on 1st July of the year empanelment. Option D, no age criteria. The correct answer is option C, not more than 70 years as on 1st July of the year of empanelment. Question number 2. What will be paid to the retired officials appointed as inquiry officer? Option A, lump sum remuneration. Option B, amount of clerical and stenographic work. Option C, conveyance charges. Option D, all the above. The correct answer is option D, all the above. Question number 3. Inquiry to be dash when application is made against inquiry officer's appointment on ground of bias. Option A, continued. Option B, cancelled. Option C, continued with new inquiry authority. Option D is stayed. The correct answer is option D, stayed, till that application is disposed. Question number 4. While engaging the defense assistant, whether the person posted in another station that is other than headquarters of charge official can be considered. Option A, yes, no restriction. Option B, yes, if permitted by inquiry authority. Option C, yes, if permitted by disciplinary authority. Option D, not permitted. The correct answer is option B, yes, if permitted by inquiry authority. Question number 5. Ceiling for retired government servants to appear as defense assistant. Option A, 5. Option B, 6. Option C, 7. Option D, 8. The correct answer is option D, 8. That is as per Directorate Letter number 17-31 bar 2016-GDS dated 16/9/2019. There is a little bit ambiguity about this particular question, and this is very important too. Hence, please refer the latest orders. Thank you. Question number 6. Whether the legal practitioner can be engaged for the defense as per CCS CCA Rules 1965. Option A, yes, if presenting officer is legal practitioner. Option B, yes, if inquiry officer is a legal practitioner. Option C, yes, only if both presenting and inquiry officer is legal practitioner. Option D, not permitted. The correct answer is option A, yes, if presenting officer is a legal practitioner. Question number 7. Government servant against whom the department inquiry is initiated can access the said documents. Option A, yes, only the document to which reference has been made in the statement of allegations. Option B, yes, all document except preliminary inquiry report or investigation made by the police. Option C, yes, only the document and records other than that mentioned in statement of allegation. Option D, yes, all records relevant to the inquiry. The correct option is yes, all the records relevant to the inquiry. Question number 8. While examining the witness, after completion of examination in chief, the following activity should happen. Option A, re-examination. Option B, cross-examination. Option C, examination by IO. Option D, preparation of daily orders. The correct answer is option B, cross-examination. Question number 9. While charge sheet issued under Rule 14 of CCS CCA Rules, can the disciplinary authority impose an minor penalty after due consideration of the defense submitted by the accused officer? Option A, yes, disciplinary authority is empowered. Option B, no, formal inquiry should be done to decide the quantum of penalty. Option C, disciplinary authority can drop the charge sheet even without inquiry in the defense submitted by accused officer is justifiable. Option D, once offense submitted by accused officer, ex parte inquiry can be ordered. The correct answer is no. For option B, no. Formal inquiry should be done to decide the quantum of penalty if it is a Rule 14 charge sheet. Question number 10. Whether inquiry authority issue charge sheet? Option A, yes, if charged official misbehave during inquiry. Option B, yes, if charged official or department witness misbehave during inquiry. Option C, yes, only for presiding officer if he misbehave with IO. Option D, no. The correct answer is no. Question number 11. He or she cannot be appointed as IO or PO. Option A, charged official. Option B, witness. Option C, either A or B. Option D, both A and B. The correct answer is option D, both A and B. Question number 12. Whether the government official under suspension can work as defense assistant for any other case. Option A, no. Option B, only after revoke of suspension he can. Option C, no guidelines on this. Option D, yes. The correct answer is option D, yes. Question number 13. Legal practitioner can be taken as defense assistants only if option A, he is registered under Bar Council. Option B, only in cases involves major penalties. Option C, only if presiding officer is legal practitioner. Option D, only in the case of Group A where matter is referred to UPSC. Option C, that is only if presiding officer is legal practitioner, is the correct answer. Question number 14. While charged official cross-examination the department witnesses, if he asks irrelevant questions, option A, witness has to answer because during cross-examination, accused official will have full power to ask question. Option B, presenting officer can answer on behalf of witness if witness is unable to answer. Option C, inquiry authority can control and even refuse to allow cross-examination. In such case, he has to justify his act. Option D, IO should allow questions and report to disciplinary authority for act of a charged official. The correct answer is IO can control and even refuse to allow cross-examination. In such case, he has to justify his act. Option C is a correct answer. Question number 15. Government servant refused to appear as witness. Option A. Government servant has full rights to refuse to appear as witness as it is a matter of right. Option B. Government servant cannot refuse to appear as witness. If he refuses, disciplinary action can be initiated against him. Option C. Government servant cannot ordinarily refuse, but even if he refuses, no disciplinary action can be initiated against him. Option D. If government servant refuses to appear as witness, he can be suspended immediately. The correct answer is option B. Government servant cannot refuse to appear as witness. If he refuses, disciplinary action can be initiated against him. Question number 16. When the copies of oral statements of witnesses can be provided to the charged officials? Option A. Once the IO submits his final report to disciplinary authorities. Option B. Only after PO submits his PO brief to IO. Option C. Before charged official called upon for his own statement before IO. Option D. The oral statements of witness cannot be given to charged officials. The correct answer is option C. Before charged official called upon for his own statement before IO. Question number 17. After completion of production of evidences, inquiry authority should order to produce oral or written brief from option A. Presenting officer, option B. Charged official, option C. Witnesses, option D. Disciplinary authority. Option A. Presenting officer is the correct answer. Question number 18. Can the disciplinary authority can work as inquiry officer? Option A, yes. Option B, no. The correct answer is option A, yes. But it is stated that normally in the major cases, disciplinary authority should appoint another person as an inquiry officer. Question number 9. Presenting officer brief should be provided to the charged official for submitting his brief by option A. Presenting officer, option B. Appellate authority, option C. Inquiry officer, option D. Disciplinary authority. The correct answer is option C. Inquiry officer. Question number 20. Once disciplinary authority provided the copy of inquiry officer report to charged official, which may be in favor of official or not, the charged official can give his representation within dash days to disciplinary authority based on IO report. Option A 90 days, option B 60 days, option C 30 days, option D 15 days. The correct answer is option D 15 days. Question number 21. For providing more weightage to the case, the disciplinary authority before giving final punishment order as per Rule 11 of CCS CCA Rules considered the past bad records of the charged official. Option A, yes, it should be considered especially when ordered for major penalties. Option B, yes, it can be considered for all penalties mentioned under Rule 11. Option C, no. Past bad records can be considered only by appellate authority. Option D, no. Past bad records should not be considered unless it is one of the specific charges in the charge sheet itself. The correct answer is option D. No, past bad records should not be considered unless it is one of the specific charges in the charge sheet itself. Question number 22. Rule 15 of CCS CCA Rule speaks about option A. Ex parte inquiry, option B. De novo proceedings, option C. Action on inquiry report, option D. Powers of disciplinary authority. The correct answer is option C. Action on inquiry report. Question number 23. On death of the charged official before completion of the disciplinary proceedings, option A. Charged official name will be dropped from the charge sheet. Option B. Disciplinary proceedings will be closed immediately. Option C. Disciplinary proceedings will be continued only with subsidiary offenders. Option D. Proceedings will be continued as ex parte, but no penalty will be imposed except monetary recovery from any legal heir. The correct answer is option B. Disciplinary proceedings will be closed immediately. Question number 24. On completion of disciplinary proceedings, it is considered that the official concerned deserves to be penalized but doesn't deserve serious punishment. The disciplinary authority can: option A. Issue warning, and warning can be recorded in a service book. Option B. Minimum censure should be issued. Option C. If it is a Rule 14 case, charge sheet can be dropped and fresh charge sheet for Rule 16 can be issued. Option D. Disciplinary authority can recommend for dropping charges to appellate authority. The correct answer is option B. Minimum censure should be issued. Question number 25. The charged official committed fraud on 1/1/2019 and was on suspension since 1/1/2020. And on completion of disciplinary proceeding, the disciplinary authority imposed penalty on 1/10/2020, that is, dismissal from service with effect from 1/1/2020. Whether the action of disciplinary authority is in order. Option A. No. The order of dismissal from service should have been imposed from 1/1/2019. Option B. No. The order of dismissal from service should have been imposed from 1/10/2020. Option C. Yes. The order of disciplinary authority is in order. Option D. Once the official is on suspension, he cannot be dismissed from service. He should be removed from service. The correct answer is option B. No, the order of dismissal from service should have been imposed from 1/10/2020. No retrospective effect.
You can follow us by being a subscriber in YouTube or through WhatsApp, Telegram, Facebook.
Thanks for watching Study Room. Please subscribe if you have not subscribed our channel. We are preparing in each video 25 questions taken from CCS CCA rules, and we are going in depth. Hence, more series will follow. So please watch all the series and get the benefit. Thank you, friends.